The 81-page charge sheet detailing 47 counts of fraud, theft, money laundering, corruption and racketeering has set out in devastating detail allegations of how the first 8 men arrested on Wednesday stole 2.2 billion rand from VBS Mutual Bank and how they tried to cover it up. Joining us to look at the charges in greater detail is attorney David Akani Sithole from David Akani Sithole Attorneys. A very good morning to you, David. Thank you for joining me on Weekend Dawn. Really appreciate it. Now, my first question, is there a possibility that we'll see more charges added to this case?
Thank you, Jacob, for having me, and greeting to the viewers at home. Indeed, when the charges, the indictment are served upon certain accused persons, the investigations may be well underway and continue under the circumstances. So there is a likely possibility that there will be further evidence that is unearthed, that further persons may be implicated in that process. So we may indeed expect to have further charges or indictments against new people.
Now, is there a specific reason why the suspects are accused of stealing less money than initially reported when the story broke?
The indictment, Jacob, is informed by the evidence that is currently available or which is reasonably expected to be procured in the process of furthering the investigations. So it may well be that when further evidence is unearthed, which may well support the initial report pertaining to the amounts, moving from the 2.2 billion to whatever amount that may have been reported, that may come about. And it's also possible that in the process of furthering the investigations, it's established that certain transactions which are suspected to be corrupt, to be theft, in that fashion are in fact not. So the figure may in fact decrease in that fashion.
Now, David, there's a lot of cases, charges involved in this case, including money laundering, racketeering, as well as fraud, etc. Can we expect more charges to be added there? And with all of those charges that are involved, what's the average jail time that these accused could spend in jail?
With regards to these offenses, these are very serious offenses, and the legislative intent is that you may be convicted to up to life sentence, and they are also facing, if it's established that it's an organized crime, it's a criminal enterprise, in that session, we are looking at a minimum sentence of 15 years up to life sentence. Of course, depending on the court, you'll have to make certain considerations such as the nature of the offense, which is obviously the serious offense, look at the particular circumstances of the individual accused, understand their charge. There are a number of accused persons that have been indicted. By the court, you look at the personal circumstances of each accused person, and of course, look at the interest of justice, the call that there must be harsher sentence for persons that contravene certain provisions of our law.
And if we look at the NPA at the moment, do they have a strong case against the accused?
So at this stage, we may not establish whether there is indeed a strong case or not, but that will be informed by the investigations that will be carried out, and of course, if we have had sight of the evidence that they've gathered thus far. But to bring an indictment in that session, it's quite detailed. It gives sufficient information in that session, but whether or not they have the requisite amount of evidence to back each and every indictment that is there, it's something that is still to be established. But at this stage, we know that there are facts that support the charges, but we do not know that they will be able to source the necessary documentary evidence required. They will be able to secure the attendance of witnesses that may give oral evidence in support of such indictment. That is still to be established as the matter goes forward.
David, I'm thinking about the people that had invested a lot of money into this bank and are now left without money in their pockets. Do you think that the whole court process will also require the accused to, make a payment plan to pay back the money?
The Criminal Procedure Act, Jacob, makes provision for such. So are the circumstances where it's not entirely a criminal process, a civil process, but the criminal procedure process itself makes provision for the circumstances where an accused person has committed an offense that has caused some damage. So there is a monetary damage that may be recovered. So if you've stolen those billions which are alleged to have been stolen, 2.1 billion, the court may, if that is part of the application which the prosecution makes, that there be recovery of such money. There is such process in which that 2.1 billion, if it is indeed the amount that has been stolen, if at all monies have been stolen, then that money can be recovered from such persons. And that's not exclusive to corruption matters or theft matters. That is in matters that cause damages in general. So there may be such request for the recovery of such monies.
I quickly want to touch on the bail issue, where they requested bail to be less. I think it was set at around 100,000 rand, and they requested that it be 50,000 rand. Is this some sort of tactic to plead poverty?
Well, you know, Jacob, the aspect of bail, this is the issue that really concerns me in general when I think about bail, because in my view, bail is not punitive. If we are going to say South Africa accepts that, or we maintain the innocence of an individual before they are proven to be guilty, the aspect of bail, why do we raise those figures to that magnitude? If you are saying we accept you still at this stage innocent, you need to prove the prosecution needs to prove your guilt in that fashion. If guilt has not been proven, there is no need to raise figures up high, because what we need to do is to enable the accused persons, to be tried, fair trial. We establish if indeed they are guilty in those circumstances. They may well not have resources, but when you look at all the circumstances provided for in terms of the Criminal Procedure Act that permit bail, that it will be in the interest of justice for bail to be granted under the circumstances, then you find that there are persons who are not out on bail, but the interest of justice do permit because of that aspect of the figure, the money. So the law makes provision for the reduction of bail to ensure that persons who duly qualify, people who will not tamper with investigations, people who are not flight risk, are allowed to be tried whilst they're outside. So the reason is you find that a person is eventually not found guilty of an offense, but then they've been in gaol, they've been waiting in prison, and injustice is occurs in that fashion.
David Akani Sithole, we'll leave it right there. David Akani Sithole is from David Akani Sithole Attorneys. Thank you so much for your time. He was speaking to us about the 81-page charge sheet that has been brought against the 8 suspects arrested for the multi-billion rand VBS bank heist.